The deponent, who is the acting chief executive officer at the time, says the following in paragraph 43. Moreover, I am advised that the minister is essentially asking the court to insert itself into the functioning of the executive branch in a manner that raises a significant question of separation of powers under the Constitution. In this regard, even if the minister correctly concluded that the Oakbay group asked him to intervene in support of its dispute with its banks, which I strongly deny, I see no reason why the minister felt compelled to act at all. So that we will submit that this is one of the passages in the report manifesting a version by Oakbay Group that there exists a dispute between it and its banks, and that includes Standard Bank. The second part of the report is page 1029 in the same volume. And it is paragraph 94 on page 1029. It is the last paragraph on that page. And the deponent says the following: I submit that these inferences should become the subject of further investigation and decisive action. These practices by the four major banks, aided by the Reserve Bank, continue today. So that is one of the paragraphs which Oakbay tells the court that its preferred method of resolving the dispute between it and the bank is further investigation, which requires decisive action, because the conduct of the bank, and we know that the only conduct of the bank about which it complains is the termination of the banking services, is aided by the Reserve Bank and continues today.
Could I just pose this to you? I think you're correct that there is a dispute between your clients and the Oakbay Group. And I'm sure you'll agree with me that we are not in these proceedings requested to resolve that dispute. Now, when you go further to Oakbay's method of resolving that dispute, I suppose you're advancing these arguments to leading to why your clients want the extended relief. But in the normal course of things, you agree that that's not for us to resolve. What would prevent Standard Bank, in case any of these individuals or offices that the Oakbay Group identifies as the people who may assist in or who may intervene in resolving their dispute with you, what prevents Standard Bank to interdict any of such attempts rather than seek the extended relief you seek today?
We have considered that question, and may we offer the following as a response. Firstly, Oakbay Group has avoided the resolution of that dispute through court processes or through regulatory intervention. So that what it has done, and that's the third consideration we have put before the court to engage its discretionary powers, is to articulate a public campaign against Standard Bank and its competitors, to undermine the legitimacy of its decision. Let me give a simple example. you would recall that one of the complaints vociferously articulated by Oakbay against the banks is that the banks have acted anti-competitively, and the banks have acted in a collusive manner. It is quite clear that by law of this country, at least, through the democratic processes established to institutionally resolve that type of dispute, the competition authorities are the only authorized institution to investigate and resolve that issue. In other words, if you say that an institution has behaved anti-competitively or in a collusive manner together with its competitors, then the only institution established by law to resolve that issue are the competition authorities. Oakbay has not approached the competition authorities to articulate that dispute. Standard Bank will not have legal standing to institute an application for interdict to compel Oakbay to approach the competition authorities to resolve that issue.
Let me just clarify what I'm saying. What prevents Standard Bank from interdicting any minister who, unapproached by Oakbay, comes to you and says, why are you closing these accounts? That was the basis of my question.
Yes. The interdict, if Standard Bank pursue it, raises all number of practical difficulties. Firstly, we know that there are a number of ministers who, on record, have called upon Standard Bank to account for its conduct. Standard Bank has referenced the meetings of the so-called Interministerial Committee during May 2016. There is some articulation in the papers about a possible commission of inquiry as a means to intervene to resolve that dispute. Now, if Standard Bank were to consider an interdict as a viable form to prevent that impermissible intervention, it will at every turn seek to intervene each and every minister when he or she takes an action. And that becomes impractical.
That is assuming that if one minister is interdicted, the other ministers will be blind to that interdict.
Well, because they would not be bound by the interdict which is granted against one minister.
But it's an interdict that sets out what the law is regarding that type of conduct.
And we agree, the interdict is one possible means of setting up the law.
Yes.
But the more viable means of setting up the law is a declaratory order. Because once the declaratory order is pronounced by this court, it resolves the issue finally as against everyone in government.
Now, the fact that you are not satisfied with the order sought by the minister, are you saying the order as it stands is not good enough, won't be effective?
Indeed. And can I, on that score, Deputy Chief Justice, refer you to a passage?
Deputy Judge President.
Deputy Judge President. My apologies. And I hope that I'm not wrong in this predictive description of what beholds the future for you. But let me refer you to paragraph 3 of the Minister's Affidavit, because we would submit that that paragraph has not been properly given the weight it deserves in these proceedings. It is at volume 1, page 3 of paragraph 3 of the Minister's Affidavit. It's page 10, volume 1. And the minister describes the dispute before the court in the following terms. This is an application for a declaratory relief arising from a dispute relating to the powers of intervention by government in relation to the closing of private clients' account registered by the bank. This is the formulation of the dispute by the minister before the court. There is no dispute or debate between the parties that the minister's formulation of this dispute before the court is wrong.
But in paragraph 9 of the minister's affidavit, he further states that the demands or representations were made to him to represent the government
And intervene.
And we accept that. And that is why the minister himself decided to confine the relief he seek in relation to him as a minister in regards to the approaches to him. But we would submit, if this is the formulation of the dispute before the minister, there is no reason to confine the relief to the minister himself. That relief must extend to acts by government to intervene in that private law relationship between the parties. And government in that context would include the national executive.
Can I take this step further and say you are challenging the order sought by the minister as it stands?
We are supporting it, but we seek to logically extend it.
Could we move to the real issue in this argument? Because we understand this preliminary part that you argue. The real issue relating to the extended relief. Now, it goes beyond the current applicant. Am I correct?
Indeed.
It goes towards other ministers. Am I correct?
Yes, let me accept that for the moment.
Okay.
And I will indicate to the court why there is an aspect of the question which we would like to clarify. But let me accept that for now.
And it also goes to the president himself. That being the case, the way I understand South African law, and I recall sitting in one of these judgments when I was in the SCA, South African law is clear. If you want an order against someone, bring him to court. Well, don't bring him to court. Serve him with papers and tell him what order you want against him. And that person will make an election whether he defends or abides. Let's deal with it. Maybe clarify the first part of my question, because clearly the order you seek goes beyond the current minister. That's why you want it extended. We just want to know what is the legal basis for that, because those people are not here.
Justice Mlambo, I will answer that issue immediately.
Yeah.
But let me complete my references about the three pillars of the declaratory relief we have sought, we seek on behalf of Standard Bank. I have given you the two references in the Oakbay version.
Yes.
I am going to give you three references in the VR laser version, where they articulate the dispute, the means they prefer to resolve that dispute, and the illegality of that method. And let me give you the references. I'm not going to read them, because I'd like to immediately turn to the question that you posed. And we're going to answer that question specifically with reference to the decisions that you have indicated you were part of and delivered one in the SCA. Interrupting myself, one of those judgments that you delivered on the very issue which we'll submit is instructive. It is a judgment referred to in the JSC case we referenced. It's a judgment of Gordhan versus KwaZulu-Natal, which you'll remember quite well, but we'll get to it in a moment. Let me finish the references. The version of VR laser is to be found at the following passages of the record. Volume 10, page 892, paragraph 28. And then it is page 899, paragraph 37, page 901 to page 902, paragraphs 44 and 45. We have sought to identify those three main issues with reference to the version of the respondents to avoid any debate about the dispute of facts. Now, let me turn to the issue that you have raised with me about the question of the non-joinder of the national executive, including the president. Yesterday, we indicated that we're going to answer that issue with reference to three considerations. The first is that the president is not a necessary party in these proceedings. You have recalled that we have referenced the judgment of the JSC as the authority for that proposition. We have looked at the response of our learned friends for the Oakbay respondents in answer to our reliance on that judgment. The best that could come up is to dismiss our reliance on that judgment as an irrelevance. And in a footnote of the heads of VR Laser, I would not bother the court to go to that footnote. But we differ with our learned friends about the relevance of the judgment. But the judgment is important for another reason, because it references the judgment of Gordhan, which you, Judge President, delivered when you were in the SCA. I believe that the court has the bundle of authorities which was prepared by the parties. You don't have it?
You don't have it?
Well,
I don't know.
the court seemed not to have the bundle, but let me give you the passage of the JSC case where the Gordhan judgment was referenced. It is paragraph 15. And Gordhan is not in our heads, but for the purposes of our answer, can we give the citation to the court?